We'll have the underlying case. Back after a brief recess. What I have here is a plea agreement that says that Ms. Langston will plead guilty to the charge, malicious destruction of property, 200 to 1,000, with a request that restitution be determined and a Killebrew to no upfront jail. Is that a correct statement of the agreement?
Yes.
All right, buckle up, everyone. Today's case dives deep into a tense, chaotic day in Lansing, Michigan, May 19th, 2021. Officer Childs responds to a shots fired call at a local residence, and what unfolds is a tangled web of confrontations, threats, and allegations that spiral out of control. At the center, Miss Walker, the alleged victim, and Tawana Langston, the defendant accused of violating a no-contact order. From gunshots in an alleyway to social media threats, this isn't just a property dispute. It's a full-blown legal storm. Stay with us because the twists, conflicting testimonies, and courtroom drama are about to get wild. And trust me, you won't want to blink.
It's hard to hear, so be louder.
Okay.
Thank you. The lady behind you has to type your answers, so you have to give words like yes or no. If you say mm-hmm or nod your head, we haven't figured out how to type it. Please state your first and last name, spell them both.
My first name is Christie, Christie. My last name is Childs, Chiles.
Thank you. Questions for witness Childs?
Thank you. Okay, Miss Childs, how are you employed?
I'm a police officer in the city of Lansing.
And how long have you been a police officer with the city of Lansing?
Over 4 years now.
Did you have any other police experience prior to working with the city of Lansing?
No.
So is it fair to say the total amount of experience you have as a police officer is 4 years?
Yes.
Now, were you working as a police officer with the city of Lansing back on May 19th, 2021?
Yes.
Okay. And when you were working as a police officer on May 19th, 2021 with the city of Lansing, how were you dressed?
In LPD patrol uniform.
How were you traveling?
In a patrol vehicle.
Were you traveling alone or with a partner?
I don't remember, but probably alone.
Okay. Now, back on May 19th, 2021, did your duties take you to 1609 Herbert Street?
Yes.
And is that in the city of Lansing, county of Ingham?
Yes.
Okay. And why did your duties take you to that location?
I was dispatched to that location for a shots fired complaint.
That's the county of Ingham, right?
Yes.
And when you arrived to the location after getting a shots fired complaint, did you meet with anyone on scene?
Yeah, I made contact with the victim,
Okay, and who was that?
Zakia.
Did you speak with Zakia Walker that day?
Yes.
Okay. And was your understanding that she was the victim of this incident?
Yes.
Did you learn during your investigation through Miss Walker who had started this incident?
Yeah, she was approached by the defendant. She took her child.
And when you say she, do you mean Miss Walker?
Yes.
Okay. And when you say the defendant, who do you mean?
Tawana Langston.
Now, have you ever had contact with Tawana Langston?
Not that I recall.
So when you arrived on scene, what did Miss Walker tell you about Tawana Langston?
She informed me that she went to a residence to pick up her child that she has in common with Isaac Langston at a residence near Canaan here. And while she was there, she was confronted by Tawana making threats and just being aggressive with her. She advised that she currently has a no contact order against her.
And were you able to confirm whether or not there was an active no contact order in your system?
I did
Okay, how did you do that?
through the
Now, did Ms. Walker tell you whether or not Tawana Langston came to the 1609 Herbert Street location?
she did not specifically say that, from what I recall.
Did you do anything else in your investigation on May 19, 2021?
Yeah, so I searched the area of her residence for any evidence, casings in the street, video footage or anything like that.
Did you find any casings?
I did not.
Okay. Do you recall if you observed any kind of damage to any kind of property?
I looked for damage and I didn't see any damage.
And this occurred on May 19, 2021 when you responded to the location?
Yes,
And that was in City of Lansing, County of Ingham?
yes.
I have no further questions for this witness.
Cross-examination.
Thank you, Your Honor. Officer Childs, I think you mentioned Isaac Langston. Is that correct?
Is that a yes?
Yes,
You said, did you say that he has a child in common with whom? With, I didn't catch that part.
so, he has a child in common with the victim.
Ms. Walker?
Yes.
Did Ms. Walker identify any other individuals that might have been involved with this incident?
Just Isaac and Tawana.
You mentioned that you, I think specifically you were asked about casings or damage caused by gunshots. But I want to ask you, in your experience, what would you expect to see as far as physical evidence? What would you be looking for in a shots fired situation?
I would be looking for shell casings or any damage to the residents or vehicles that were in the alleyway.
And you didn't find anything like that at the time?
No.
Did you receive any, well, let me rephrase that. Did Ms. Walker say anything about Ms. Langston appearing at her residence? I'm sorry, right, about Tawana Langston appearing at her residence?
She said that she was confronted by her when she went to pick up her child. And then she later went to her own residence and then she saw Isaac driving past her house in the alleyway multiple times. And then he was screaming out the window, similar threats to what she was yelling at her previously in the evening. And as he was driving past, she heard gunshots.
You say as he was driving past, you didn't see the gun being fired?
No, because if he was driving through the alleyway, I don't think she could see the driver's side of the vehicle, but she did hear the gunshots.
So did she suggest that the gunshots occurred while he was driving through the alleyway?
Yes.
Okay. And this other location where she went to pick up her daughter, do you know, like, what is that location? Is that somebody's home?
I do believe it's somebody's residence, yes.
You know whose that would be? Did she tell you who it would be?
No, she didn't go into that with detail.
I have no further questions, Your Honor. Thank you.
Redirect?
No questions.
All right, you may step down.
Thank you, I appreciate it.
You are.
Ms. McCray,
Thank you, Your Honor. The people have no further witnesses at this time.
Mr. Raleigh.
I'm not going to be calling in witnesses, Your Honor.
Okay. We will go to argument.
Thank you, Your Honor. This is a continued hearing. You previously heard from two witnesses on another date, Ms. Walker and her daughter, Ms. Smith. Today you heard from Officer Childs. The testimony from Ms. Walker was that on the date and time and the location, she was sitting in her car in a backyard near an alley. There was an argument when the defendant arrived what I believe her testimony was Willie Smith, and that I'm just trying to review my notes, Judge, from the previous hearing. So I think they both took out a gun and shot at them. That Ms. Walker's daughter had received messages from the defendant on Facebook after the fact, saying that she was going to spit on them, stomp the daughter's baby out. Various threats. Ms. Walker testified at length that
Here's where it gets really messy. Officer Childs confirms there was a confrontation and the valid no contact order. Yet when she searched the scene, there's no physical evidence. No shell casings, no damage captured on video. Meanwhile, Ms. Walker's testimony and her daughter's statements paint a very different picture. Guns were brandished, shots were fired, and threats flew both in person and over social media. The court is now juggling two drastically different stories. This is a textbook example of why corroborating evidence is crucial. As a viewer, ask yourself, who do you believe? Can the absence of physical evidence outweigh multiple witness accounts? It's a tense legal balancing act that keeps the courtroom on edge.
the contact from Ms. Langston has been non-stop. Then Ms. Precious Smith testified. She confirmed a lot of the things that Ms. Walker had previously testified to. There was an altercation in her mom's driveway, that her dad had dropped her off with Tawana Langston in the car, that she had seen a gun when Mr. Willie Smith and her and Tawana Langston were flirting of some sorts with the gun, that she saw the defendant point a gun at Ms. Walker, and then 5 minutes later heard shots fired. She said her mom had a bullet hole in her car. She confirmed that she had received threats from the defendant, and that there were threats that continued right after the shooting. Officer Childs testified today that she responded on May 19, 2021, met with Ms. Walker, spoke with her, learned there was a confrontation with the defendant at some point that day, and confirmed that there was a valid PA 53 no contact in the system. So I do believe that the people at this time have proven beyond a reasonable doubt that this defendant violated the no contact order by having contact with the victim in this matter, Ms. Zakia Walker.
Mr. Rapp.
Thank you, Your Honor. I mean, between last week's session and today, we've heard at least two different versions of the alleged events of May 19, 2021. To be frank, I believe Ms. Walker could not even identify a date or even a year that the alleged event occurred. I mean, speaking for myself, I think if someone fired a gun at my house, I would remember it. It would be an important thing in my life. But regardless of that, I think Ms. Walker stated a very different version of events. So she was in her vehicle, that my client and Willie Smith drove up, and then some altercation occurred. And then shots were fired at, I believe, the front of the house that damaged her car or her truck, I think she said. We heard from Officer Childs today that she searched the area for evidence of any kind of damage or any shots having been fired, and she was not able to locate any physical evidence. Of course, we don't have any video or photo evidence. Again, we heard about these text messages last week, but of course we do not have those in evidence, and we can't even identify certain dates that those might have been received. Frankly, Your Honor, I just don't think there's been sufficient evidence to establish what happened, if at all. I think statements between Officer Child's investigation 2 years ago, testimony given last week, and testimony given today are so inconsistent. Frankly, I don't think anything has been established beyond any standard of evidence. Thank you.
Any rebuttal?
I just say that Your Honor heard from Ms. Walker. Your Honor also heard from Ms. Smith. I believe they were very credible on the stand and provided significant details. You know, I think that there are inconsistencies, and that I will concede that. But I think a lot of that is due to, you know, this taking so long to get to this point. And I agree that memories do fade, but I think that there has been at least a violation of the no contact order. You know, I don't want to get into whether or not, you know, all the specifics about, you know, I don't have to prove today that there was like brandishing of a weapon or that there was an AWIM or all the elements of those. I just have to prove that there is some kind of contact that occurred. And I think that based off of the testimony of Ms. Walker and her daughter, that there was some form of contact that day with this defendant and Ms. Walker. And I think that has been established beyond a reasonable doubt.
Thank you. I told you at the beginning that this was going to be held as a contempt hearing, which means the burden of proof is beyond a reasonable doubt. And the court has to determine that there is a court order and that it was in fact violated. I do believe I took judicial notice of the existence of this court order. If I didn't, I will now. That there is a court order in the file that was put in place and covered the time span when this is alleged to have occurred, because I think the prosecution's position is this occurred in May of 21. The court order was put in place in, it was extended at one point. So it was put in place originally in March of 20. And then it was renewed by Judge Alderson in, I believe, March of 21. Thus making the order valid again until 22. Part of the problem is Ms. Langston has been gone off and on, mostly gone throughout the proceedings. While I agree that the court only needs to find that the order was violated, it has to be based on reliable evidence to conclude beyond a reasonable doubt. So I have a feeling the order's been violated this time and many other times, and I think there's some kind of drama between the two halves. But on this record, the facts that have been presented are all over the place. Maybe Willie Smith's there, maybe Isaac Langston's there, maybe they're two different people, maybe they're the same person. I have no idea. But the facts that have been presented to the court are so inconsistent that I cannot conclude beyond a reasonable doubt that the violation as alleged actually occurred on this day. I can't even conclude what location, because according to Ms. Childs, the report was Ms. Langston made some confrontation with Ms. Walker at some other location. And then Isaac Langston is driving past her house and she hears gunshots, which is completely different than the story that Ms. Walker told me, where she's at her house and suddenly Ms. Langston, Mr. Smith, and her daughter pull up and there's something that happens. So as to the bond violation on this record, I can't just conclude, even though everyone's telling a different story, and I feel like there's violations occurring, that's sufficient. I'm not going to let anyone abuse the system. You're not going to tell one story to the police, tell a different story to me, have this happening, that happening, all the meanwhile, because you're having some kind of external drama. So the bond violation is dismissed, but we still have the underlying case. Back after a brief recess, what I have here is a plea agreement that says that Ms. Langston will plead guilty to the charge, malicious destruction of property, 200 to 1,000, with a request that restitution be determined and a Killebrew to no upfront jail. Is that a correct statement of the agreement?
Yes, Your Honor.
Yes, Your Honor, it is.
Ms. Langston, is that your understanding of what you've agreed to?
Yes, ma'am, it is.
Okay. Ms. Langston, taking an agreement to no upfront jail for you is high risk because you never show up. How am I gonna do this?
I learned my lesson, going to jail for 33 days, almost losing everything. My
This has been
kids,
going
my
on
house.
forever.
I know. And being in jail for 30 days, that made me learn my lesson.
And you're wishing to accept the offer?
Yes, ma'am, I am.
Malicious destruction of property is a misdemeanor with a punishment of up to 1 year in jail and or $200 to $1,000 in fines plus restitution. Misdemeanors carry up to 2 years of probation. Do you understand the possible penalties?
Yes, ma'am, I do.
You have a Killebrew agreement to no upfront jail. That means if at the time of sentencing, I were going to send you to jail, you could withdraw your plea and go to trial instead. But if I place you on probation for this offense, and you violate probation, you face up to 1 year in jail. You understand that?
Yes, ma'am, I do.
Now, if you violate the conditions of your bond between now and sentencing, you could forfeit a no upfront jail agreement. It's important that you understand that since there appears to be this like constant tit for tat thing going on.
Yes, ma'am. Won't have no more problems out of me.
It's important that you understand that criminal convictions can have other consequences. If you are a citizen, foreign travel may be restricted. If you're not a citizen, you may be removed from the country, excluded from admission to the country, or denied naturalization as a citizen. You have the right to have an attorney in this matter, and Mr. Raleigh is representing you. You have the right to a trial that could be by jury. I have here an advice of rights form from last week. Do you remember going over an advice of rights form last week with Mr. Raleigh?
Yes, ma'am.
Did you sign that?
Yes, ma'am, I did.
Have you had the chance to ask Mr. Raleigh all of your questions?
Yes, ma'am, I did.
Do you understand that if you proceed with pleading guilty, you will give up these rights? There will not be a trial of any kind.
Yes, ma'am.
If you were on probation or parole on the day this is alleged to have occurred, January 17th of 2020, you plead guilty, you could be admitting a probation or parole violation. Are you ready to proceed with your plea?
Yes, ma'am.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes.
Ms. Langston, on January 17th of 2020, did you go to 313 West Kalamazoo Street?
Yes.
That's the circuit courthouse, the other courthouse.
Yes, ma'am.
Okay, and that's in the city of Lansing, Yangon County.
Yes, ma'am.
And did you find it around that location, Ms. Walker's motor vehicle?
Yes, ma'am.
Did you do something to it?
Yes, ma'am, I did.
What did you do?
I kicked it with my foot.
Kicked it with your foot, and what damage did that do?
Break her passenger's window.
Okay, so you kicked pretty high.
Yes.
Okay. All right, and you agree that that window probably has a value of over $200?
Yes, ma'am.
That was on purpose?
Hmm?
Kicked the window on purpose?
Yes, ma'am.
Any additional questions on the factual basis?
No, thank you, Judge.
No, Your Honor, thank you.
Did anyone make any promises or threats to you other than this plea agreement to get you to plead guilty here today?
No, ma'am.
Are you pleading guilty of your own free choice?
Yes, ma'am, I am.
And to the charge, malicious destruction of property with a value of $200 to $1,000, how do you plead?
Guilty.
Finding guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record on which to base your plea. It's therefore accepted. We have to set this for a sentencing date as there's crime victim rights as well as a restitution hearing needs to occur that day. Ms. Langston, do you have anything else holding you in jail besides this right now?
No. No, ma'am, I don't.
Sentencing will be August 22nd at 1 o'clock in person. That's when we'll determine restitution as well. Guess we should talk about bond then. Mr. Raleigh?
Yes, Your Honor, my client has been in custody since June 5th. Of course, today the alleged bond violation was dismissed. My client just entered a plea that involves those reasons I would ask that she be allowed a personal recognizance bond until the date of sentencing.
Ms. McCray?
People would object, any reduction to bond. I'd like
Well, I have
to,
to say Avon, she's on remand right now because
oh,
she didn't show up for a jury trial a couple times.
okay, then, I would ask for, 5,000 cash. Part of her bond, if your honor is inclined to give her something else, I would ask for a GPS tether with victim notification. My fear is that we want to get this over with. We want to have this sentencing. We want to be done and have this restitution hearing. So that's the people's position.
For the record, Your Honor, my client would not object to a GPS tether if that were to be ordered.
I'll order bond in the amount of $2,000 personal recognizance with a GPS tether with a zone surrounding the address that Ms. Walker gave on Herbert Street as her residence. With victim notification if possible, no contact with Ms. Walker, not to be within 2,000 feet of where she lives, works, or goes to school. No out-of-state travel, no alcohol, marijuana, or illegal drugs, no firearms or dangerous weapons at all. Probation is going to want to interview you before a sentencing date. If they don't see you while you're in custody today, then you need to come in within the next couple of days to fill out your paperwork. So you have 2 days
Okay.
to get in here, fill out your risk assessment, your questionnaire, and then they'll set up the time to interview you.
Okay.
Okay. So you won't be released till you actually have that tether on, and your attorney can explain that if you don't have the finances for it, you may qualify for the grant-funded indigent assistance. Make sure you follow through on that, though. If they put the tether on you on the promise you're going to return with your proof, Medicaid or whatever else they want, if you don't turn up with it, then we issue a warrant. So you
Okay.
gotta follow through.
Okay, my sister here, she got my cards and stuff anyway.
Okay, good. Because Ms. Langston, it's just, you have made this file much, much thicker and much more than it should have been. This all started with a broken window. You could have paid for the broken window and been moved on. Instead, we're doing this.
I learned my lesson. I'm coming to court. I definitely learned my lesson. Jail, that's traumatized me.
Mr. Warren's is gonna get your paperwork and then he's gonna take you back down.
Thank you.
Please subscribe to help the channel.
In the end, the court had to navigate a maze of conflicting testimony, missing evidence, and legal technicalities. While the alleged bond violation was dismissed due to inconsistent accounts, the plea agreement for destruction of property moves forward. Tawana Langston pled guilty, acknowledging that a vehicle window was intentionally damaged, setting the stage for restitution and sentencing. This case highlights the complexities of courtroom proceedings. Even seemingly straightforward incidents can become intricate legal puzzles when memory, perception, and evidence collide. If you found this case as jaw-dropping as we did, from alleyway gunfire to legal drama, make sure to hit like, share your thoughts in the comments, and subscribe for more high-stakes courtroom breakdowns.